Yeah, just hit it. Welcome, everyone. People coming in. All right, I can already see some familiar names. Good afternoon, everybody. A couple more people coming in, and we may expect more. I'm just going to give a context for what this webinar is today, and then hand it over to our colleagues, Felicia and Avi from Athene Law. So I'm Brian Rutledge, your executive director. Everyone on here is a member, so you already know me. We really appreciate you joining us today. We had scheduled this webinar about managed care disputes a couple months ago in the context of the DHCS issue. Uh, so we wanted to make sure providers had context on what managed care requirements are in terms of recoupments and things like that, what provider options are. So this was designed to be a general overview, so you're familiar with the landscape and with your options. Now, however, there is a Health Net situation, as you all know, where Health Net is actively seeking clawbacks related to the DHCS 10% increase. Um, I want to be clear about how this webinar deals with that issue. So next week, next Thursday, we're going to host a webinar specific to the healthcare situation or the Health Net situation. So please join us again next Thursday for more information on exactly what to expect from Health Net in terms of their actions going forward and to think more with you about your options in responding to Health Net. So next week we'll be specifically focusing on Health Net and how to respond. This week, this webinar is going to offer you really powerful information about the context. It will offer you more thinking through of your options on Health Net, but it'll do more than that because it'll be applicable to all managed care. So I did want to make that distinction up front that this is about all managed care plans. This is about the general landscape and the options that apply in all sorts of situations where you can dispute things with them. And next week we'll dive into that case study, that very live, happening in a real-time situation with HealthNet. So with that, I want to thank our colleagues. Felicia is the founding partner and CEO of Athene Law, and Avi is counsel for Athene Law. They both have massive experience. I'll let them say more about themselves so you guys are familiar with who they are. But thank you, Felicia and Avi, for being here, and I'll drop off. And just thank you guys for doing this.
Thanks, Brian. And it's always such a treat to be able to present with CAADS. I've been working on and off with CAADS since probably the late 2000s. So it's been likely over 15 years. And it's such an amazing organization. It's always been so dedicated to making sure that we're able to care for some of the most vulnerable members of California society and making sure there was that difficult transition from ADHD to CBAS. They were strong advocates then, and I really respect them for that. So always happy to be here. So this is actually not the original bio that we had up, but my name is Felicia. I founded this law firm about 7 years ago, and I am the managing partner. I deal with a lot of Medi-Cal, Medicare issues, including managed care. Back about 15 years ago, when they had the 10% across the board rate cuts, I had worked with Lydia Miselides on the litigation against DHCS. That ended up getting that enjoined, and then, obviously that ended up being reversed later on. With me today is Avi Rushman. Avi, you want to go ahead and introduce yourself?
Yeah, thanks, Felicia. Hi, everyone. My name is Avi Rutschman. I am a counsel at Athene. I've been with the firm for the past 3 years, and for the past 10 years overall, I've been a litigator. Actually got my start in healthcare, dealing a lot with fraud and abuse in my early days. Now, my practice primarily focuses on litigating out-of-network reasonable value disputes, various types of managed care disputes, as well as lawsuits against DHCS. So like Felicia, I'm really happy to be here and to help you unwind the labyrinthian world of managed care disputes.
So just a quick note as we get going, there is a little Q&A button. You're welcome to type questions in there. We'll try to get to them as we go. Or Brian, I don't know if you wanted to save questions until the end, but Brian, if it's something that's topical, relevant to something we're talking about, feel free to just butt in and let us know.
Sounds
Um,
great.
So we're focused, well, this is CBAS, so we're focused on Medi-Cal managed care. We're gonna do a little bit of overview that might overlap with some of the things that our colleague Kyle talked about a few weeks ago. But it makes sense because again, the rules that govern every single type of plan that you may work with are based on what kinds of plans they are. So we're gonna go through that very quickly. And then some provider best practices to avoid disputes. It's sort of like, well, how are you operating every single day? We always want to avoid disputes, but if they come, we want to be ready for them. Then how to pursue disputes with plans, common managed care issues. So we're going to walk through, once we've kind of gone through the process and the law and some of this, we're going to walk through some common managed care issues that arise and sort of walk through what we would recommend in those particular situations. And then lastly, talk about some other creative advocacy strategies. We know that right now it is really difficult. I am involved, I'm the outside general counsel to two hospital associations. One of them has been convening a group talking about all of the claim processing delays and excess denials that they've had. And we found patterns across systems of hospitals. Earlier this week, I was speaking to a group of rural health clinics. They're facing a lot of the same issues. And this is something that I know we actually just did an event yesterday with the California Medical Association. It is something that I know they are also looking at. And so it's something that is difficult. It is unfortunately integrated into our current healthcare system. I wish it wasn't. But we are hoping that we might be able to give you some strategies on how to minimize disputes and then how to pursue disputes so that you can efficiently get to better results. So moving to the next slide, we're gonna start with just very quickly going through Medi-Cal managed care. As you know, earlier in the last 3 to 4 years, the Department of Healthcare Services has completely revamped the way that the Medi-Cal managed care purchasing happens in the state of California. The hope is eventually to move 99% of all Medi-Cal individuals into managed care. Obviously, CBS was moved into managed care as over 10 years ago. So whereas before there were fewer models, there are now more models as they've expanded and really listened to local influence in terms of what kinds of managed care is working for them. So there are 5 models employed currently, and it says county election. That's a little bit of a misnomer. It's not necessarily that the county itself gets to choose, but it's based on what DHCS chooses for that particular county. So we have county operated health systems. This is probably the one to pay the most attention to because these county operated health systems are pseudo-public, so they get certain protections from that. But more importantly, they are exempt from the Knox-Keene Act. So a lot of them do have licenses. Like for example, CalOptima operates a Medicare Advantage line. For that Medicare Advantage line, it has a Knox-Keene Act license, but that licensure is inapplicable to its Medi-Cal line of business. One of the other things that's unique about county organized health systems is that they are also exempt from federal regulations that govern Medicaid managed care organizations. And so there is a whole slew of requirements that are imposed on Medicaid managed care organizations in the Code of Federal Register by CMS. Those don't apply to these county organized health systems. That sounds like a lot, but most often DHCS then turns around and imposes those same requirements on the county organized health systems by contract. So realistically, they have to comply with a lot of what the other plans do, but they don't absolutely have to comply with everything that the other plans do. Then you've got the two plan model, which is like LA County, where you've got the two main the two main plans. Oh, and then you have geographic managed care, which has historically been San Diego and Sacramento, where you have a number of plans to choose from. You've got regional, which is a lot like two plan, except instead of having a local initiative health plan, you have two commercial plans that are serving, a county or a region. And then you have the single plan, which is, what you're seeing in Imperial, technically a single plan. And then you've got some other counties where it's just one single Knox-Keene Act licensed local government run plan. Layered on top of this, which is not depicted on this slide, is the fact that as of January 1, 2024, the state of California negotiated a statewide contract with Kaiser, which operates as a Medi-Cal managed care plan in most of the areas where Kaiser does a significant amount of business. So like, for example, LA County, we call it a two-plan model, but at the end of the day, it's two plans plus Kaiser. And that is, that is another place that that is another plan that we need to keep in consideration. So going to the next slide, which is just sort of reviewing what I just said, is that, next slide, please. Thank you. Paying attention to the type of plan that you're contracting with is important because there are different rules that apply for the different plans, particularly with respect to CAADS, but even some of the other public plans like LA Care, for example. LA Care is going to argue that because it's a pseudo-public entity, it has certain rights that would be afforded to another kind of public agency. We're going to talk about some of those things like the Government Claims Act, but there are also, in addition to Government Claims Act, there are also slight differences when it comes to issues with false claims and reverse false claims, which deals with overpayments that can arise with public plans because they are considered public entities for the purposes of the State False Claims Act. Okay, moving to the next slide. So we have a slew of rules, and I don't expect you to know these. This is one of the reasons, hopefully, that there are, why we still use lawyers. But just so you have a sense, there is a whole slew of rules that apply to what your operation is with the health plan. So you've got the federal Medicaid statute and regulations. And again, the regulations don't apply to CAADS, but the regulations are pretty much all found in 42 CFR Part 438, if you ever want to look at it. You then have the Medi-Cal statutes and regulations, and those are in the Welfare and Institutions Code and the California Code of Regulations, Title 22. Sorry for the slight typo on that one. You then have, for the Knox-Keene Act, the healthcare service plans, they're also subject to Knox-Keene Act rules and regulations. But I will say that in some ways, when there is both an overlapping Medi-Cal and a Knox-Keene rule, in theory, it should be that the plan has to meet the higher of the two, the one that is stricter, the rule that is more strict. But when it comes to actually how that gets applied between the governmental and agencies, a lot of times they are going to defer to the Medi-Cal rule. All right, so then moving to, oh, not yet. Then there's also the authority for Medi-Cal managed care is in what is called the CAAAM waiver. Most of it is now in what's called the 1915B waiver. But in order to operate in the CBAS, the authority for CBAS is in the CalAIM waiver. We have to double check that to make sure that the plans are in compliance. Then each plan also has a contract with DHCS. The contract with DHCS, there's a boilerplate contract that you can find online. It has a lot of language that spells out what the plan is required to do, what DHCS is expecting the plan to do with vis-a-vis CBAS. So if you haven't ever looked at that document and you start to get in a point where you're looking to escalate a dispute with a plan, it is good to know what DHCS has told them they must do. And DHCS sometimes also, and I will talk about all plan letters a little bit in this presentation, also issues underground guidance to DHCS, underground meaning that it's not an official regulation. And that's something that that the plans all take as basically law. So that's something else to look at. Then, of course, when it comes down to you as a provider, you're governed by the contract with the plan, as well as the plan policies and procedures, which in provider manual, which you typically will see are incorporated into the contract, into your contract. All right, so next thing, we're gonna start talking about, sort of what are best practices. Because we know that you are more expert than Avi and I ever will be at what you need to do to run a CBAS program, right? But what we can do is we can tell you these are things that we see over and over again, things that may even seem common sense. And the reason is just because these are problems that we consistently see and we are not, and are really important when we get engaged to help escalate a dispute. These are things that we come across where, boy, we really just wished you had some of these things that would really help help us be able to show your case. So I know our colleague Kyle a few weeks ago, he emphasized maintaining your contract. Whether you're doing it on paper or whether you're doing it through electronic files, having a file with your original contract, having every amendment to the plan. So you're getting annual amendments all the time, making sure that you're taking a look at it, making sure there's nothing in there that's a huge red flag, making sure that you're keeping it. One of the things we often find is that we have a dispute, and disputes are rarely just for the last 6 months. A lot of times we're looking at disputes that might be a couple years old. But if you don't have a copy of the contract that applied a couple years ago, that's not going to help you assess what your rights and remedies might be. So making sure you keep track of that contract over time. I also do have some clients who, unfortunately, once they get an amendment, that's what they think of as their contract, and they toss the original contract, and then we don't have access to it. So and then I have actually ended up in a situation where the plan and the provider both think they're contracted, and they've been acting like they've been contracted forever, but neither party actually has access to the contract, and we're just guessing what the terms are. So making sure that you keep your contract is actually really, really important. In addition to that, making sure you keep copies of important plan correspondence, things like the provider manual, changes to the provider manual, fee schedule announcing, billing and coding announcements, benefit changes, anything like this that's really going to affect the way your relationship with the plan is structured is really important. For example, right now, Avi and I have been involved in litigation against LA Care for about 3 years. They did not amend a single contract to make a policy change. They decided that they were no longer going to cover a certain category of services. All they did was they did a notice of billing, of sort of a billing change to a subset of their providers. But it wasn't a huge notice. It got missed left and right. And it wasn't even a policy. It wasn't in their provider manual. You can't find it anywhere. It's not on their website. So those are things that that's the way in which the plans are notifying you of things that could really have a significant impact on your, your ability to get paid and the way you code things or what's going to get authorized. So making sure you retain those is really important. So switching to the next, so that goes back to just document everything. Document your claim submissions, your authorizations, but really, and that's all obvious stuff, but anytime, and it's funny because now I think about this, when I first started working at the US Department of Health and Human Services, one of the things we had to do after every call, I was an investigator, I had to write down notes of exactly what happened in every call. And now in this digital age, that's not always my habit anymore. But it is really important. Anytime you're talking to case managers or provider network representative, and they're telling you things about rates or about the contract or what your contract means, you want to make sure you have written documentation of it. It's really difficult when we say, oh, well, they told us they were going to pay for this service. And then later you looking at the documentation, there's nothing that substantiates it. At least if we have a business record that's as of the time, and you can say, so and so told us this, it's going to give us something that can substantiate what you understand. You can also use email to confirm things that are said, and that's going to help a lot, set a record for later. And then obviously your system should be, if you're in on an electronic system, it should be keeping your EOBs and denials. If you're on a paper system, make sure you're retaining that. So then with respect to authorizations, I know that this is something that you all have worked really hard on. There was such a bumpy road when we moved from ADHTC to CBAS. But I know there are still problems with the system. There's never a perfect system. And so, making sure that you keep track. I know that different plans have different forms for authorization for CBAS. And for eligibility determinations, they have slightly different processes. And so make sure for your local plans, you're keeping track of that, keeping your authorizations from the plan, making sure you're getting the right documentation over that. One thing that's important to remember is that once the plans have approved under the Knox-Keene Act, once the plans have approved authorization of the services, if you render those authorized services in good faith, based on that authorization, they can't retroactively rescind or modify that authorization. We still see that happen sometimes, and it shouldn't happen. So if you have documentation that says we authorize the service on July 24th, you provide the service on July 24th. They can't come back and say, oh, on July 26th, oh, we made a mistake. That's not what we meant. You're no longer authorized for July 24th. That is not permissible. Next slide. So then keeping track of the timeframes, the plans have typically 5 business days, I would think, for CBAS to respond to requests for authorizations. If they don't have all the information they need, that can be extended to 14 calendar days. If they fail to issue a decision, it acts as an automatic denial, and it's going to be the same thing with claims. No news in this case is not good news. No news means that your request is likely been denied. It will be treated as denied. So one of the things that was a problem historically was that authorizations were being determined by non-healthcare professionals. And so it is now the rule that qualified healthcare professionals must supervise review of the plans. There is requirement as to what the notice must include, as to why they are denying, deferring, or modifying a service. So they have to have a written explanation. They have to describe the criteria or guidelines used and the clinical reasons for the decision based on medical necessity. And any written communication must also include the name and telephone number of the contractor's healthcare professional responsible for the denial, delay, or modification. Now, technically, the DHCS contract does allow them to notify a provider over the phone, but in actual practice, what we see is that this is usually being done in writing. So this denial of an authorization, it affects you as a provider because you want to provide that service and you're trying to, render service to the individual. But it also impacts the client that you're trying to serve, because at that point, the client believes that he or she requires a specific service. And here you have Medi-Cal, which is fundamentally a government program, saying, no, we're not going to let you have this service. So in that case, there is a requirement. So fundamentally, when you talk about any kind of government benefit, as lawyers, we always talk about should always be notice. So you have to know that the government's doing something to you, and a right to appeal. So when there is a denial, delay, or modification of authorization, there must be a written notice to the client that triggers appeal rights. And that typically will go to both the provider and the plan's enrollee. So that then triggers an appeal process. Now, this is, so you have the provider dispute resolution mechanism. We're going to talk about that a little bit. But those of you who aren't using the enrollee mechanism might want to consider doing that. What that mechanism is, you have 60 days to appeal the denial to the plan. The plan's got to acknowledge the appeal within 5 days and then respond within 30 days, typically, or 72 hours if it's expedited. So if it's granted, the plan must authorize the services or pay for the services within 72 hours. If it's denied, the enrollee can seek a state fair hearing or independent medical review. So I should say this very clear. I think I forgot to say this in the second bullet point. So you're basically standing in, when you go through this beneficiary appeal process, you're standing in the shoes of the individual who is seeking services. You're not just fighting for your own interests as a CBAS provider. So in that case, you have to have consent, preferably in writing, from the client saying that, yeah, we're going to let you fight this on our behalf. And they might do that because you're a little bit more sophisticated, you have more familiarity with these kinds of processes. I'm thinking about some of the CVS centers I know of. The particular client may not be fluent in English. There might be a lot of reasons why they would like you to handle it for them. And so that would be an option to use this certain process. Coming out of this process, then you have two options. So next slide. So the first one is what we call a state fair hearing. Since the beginning of time, it's been, well, not the beginning of time, since 1965 when Medicaid was enacted. There's always been, the states have always had to have a process where they have a state fair hearing system that considers denials of benefits. It involves a hearing with an administrative law judge who reviews the case. The attorneys are permitted. I've actually appeared at a couple of these. The hearing can be held in person, by phone, or video conference, but I always like, if I can, to do these in person. And the patient or representative of the plan are permitted to introduce evidence and question witnesses. At the end of the day, the plan typically will produce its file that it relied on to deny the service. In fact, the ones I've done, the plan typically has not shown up. Sometimes it's a little bit weird. But my experience with this is, with the state fair hearing, you get administrative law judges who already understand Medi-Cal. Sometimes I think you will come across somebody who really wants to uphold anything that the plan has done. But in other circumstances, what I've seen is that that the ALJ really wants to help the enrollee. Like they, at least the last one I was in, it seemed like they took that job because they wanted to preserve access to benefits. And so I think that that is a really good option in terms of appealing a denial of authorization. The second is an independent medical review at DMHC, which applies to Knox-Keene plans, and you're required to submit documentation, and then there's an independent doctor that reviews the documentation. I put this one second. For some services, independent medical review can be really good, and it's worth looking. The DMHC website gives you a sense of what these decisions have been like. And I feel like they're very good for traditional healthcare services. But because CBAS is not generally covered by commercial plans, my concern with using independent medical review, and obviously if any of you have had different experiences, feel free to chime in, is that they're not going to be as familiar with what CBAS is. They're probably not going to be even as familiar with the concept of long-term care or the needs of seniors. And so I think that from this perspective, give it just on my own gut and experience, I haven't brought claims to either of these. I would lean a little bit more towards the state fair hearing as a process. So next we have claim submission. I should take a second. I know we're going through a lot of things quickly. We have an hour and a half, but we also have a lot of slides. So we're actually, even though I'm talking nonstop, we're actually close to on time on this. So with claim timeliness, that's always going to be subject to your contract. It's got to be at least 90 days. Many of the plans do apply the reductions at 6 months, 9 months, and 12 months that Medi-Cal fee-for-service did. And so always better to stay on top of your AR and get those claims sent. With claim cleanliness, we hear this all the time. Plans are always asking for more information. It's maddening. It's actually going to be one of our examples. But what cleanliness means under both the Medi-Cal contract and the DMHC rules that apply to Knox-Keene plans is that the payer has to have all of the information reasonably necessary for them to essentially determine that they owe money and to process the claim. So this claim information shouldn't be rocket science, right? That this should be pretty standard, but we understand that with CBAS, as with a lot of other kinds of services, there's a continuous asking for more documentation and sometimes denials. That triggers appeal rights that in the provider dispute resolution process we're going to talk about later. But it is something, I don't know if it gives you solace to know that this is something that affects many different provider types. One thing I'll note, and especially for smaller providers, I do sometimes find that some smaller providers are still using paper billing. It's easier for a plan to adjudicate and to digest electronically billed claims. Typically speaking, if you have a contract with the plan, they will give you a login to electronically bill for the services. So I think that if your system is set up to do electronic billing rather than paper billing, it is something to consider. All right, and then the last thing is what you should expect with respect to payment. So prompt payment for clean claims, it's supposed to be within 45 working days. This is the Knox-Keene rule. Medi-Cal rule is they have to pay 90% of claims within 30 days and 99% within 90 days. But it's going to become moot because under the Knox-Keene Act, come January 1, 2026, they're supposed to be paying all claims within 30 calendar days. And then just making sure you're tracking claims and expected payment. A lot of folks will keep, a tracker of outstanding AR. And part of the reason why you want to do that is it's really important to start identifying patterns of underpayments. it's weird, you get one denial or one modification here or there, and if you're not keeping track, you don't start seeing when there are patterns, but it's when you can identify patterns that you know that you've got enough claims that it really makes sense to escalate that. Lastly, when plans do not pay timely, they are supposed to include 15% interest on late payments automatically. And in fact, shockingly, that's the only real tool that providers have for timely payment. So there was a period, boy, I want to say around 2017, where LA Care just stopped paying freestanding skilled nursing care. They just stopped. And if you know the history of LA Care, part of it was that they were never intended to actually pay claims. LA Care was set up so that it was always going to be a delegated payer model, so they weren't really set up for that. But they would sometimes take 6-12 months to pay any skilled nursing claim. But when they did it, they always included the interest. And so when you were complaining, there was sort of less to complain about because they were just always including interest. And it was only one class claims that they were always paying late. So, that's something to consider as we work through this. And I know that on smaller claims, that interest might not be huge, but especially if you've got claims that end up having lags. Avi and I just won a case. The claims there, the overpayments were over 5 years. And so the amount of interest that we gathered on that is almost as much as it's about half of what the principal originally was. So when you have real delays in payment, interest is a tool to always remember. Even if you're not serious about collecting it, it gives you another chip if you're in like discussions with a plan of something that you might be able to bargain in order to get timely payment. So I've been talking a long time. I'm going to pass the baton over to Avi, and he's going to talk about. Oh no, I'm just kidding. I got one more. But this is in addition to payments, plans have 45 working days to modify or deny payment, which is likely also going to go to the 30 calendar days. So making sure that you're keeping track of that, because that's going to start triggering timeframes for you to appeal. And moving then to the next slide, we have we're going to go through the provider dispute resolution process. And usually when we say appeal, we talk about that appeal directly to the plan. And then after that, when we talk about escalation, we're talking about going beyond the plan to other third parties. Avi?
Yep. Great. Thanks, Felicia. So next we'll discuss pursuing disputes with plans. So by now you should be familiar with best practices, and hopefully you are implementing them. You are obtaining authorizations for your services. You are submitting timely clean claims, and shockingly, plans are still denying or adjusting your claims. If this is happening to you, your next step is going to be to complete the provider dispute resolution process, also sometimes referred to as internal dispute resolution, PDR, or IDR. So PDR is mandated. Plans must offer it, but the statutes and guidance that make it a requirement only impose certain minimum requirements. This includes that the mechanism be a fast, fair, and cost-effective dispute resolution, that the time period for submitting a claim not be shorter than 365 days, and that plans provide a written determination within 45 working days. As to the remaining details of the PDR procedure, they're pretty much left to the plan's discretion, but they must be set forth in writing in your contract and also typically in the provider manual as well as the provider web portals. In some situations, PDR can actually result in a favorable resolution for the provider. Congratulations if you're one of the lucky few. But more often than not, plans are going to use it as an administrative hurdle to their benefit. Despite this harsh reality, it's important to understand that you cannot sidestep PDR. In legal terms, you must exhaust the process. So despite the burden of PDR, there are steps that you can take to ensure that when you submit disputes, they are processed more efficiently and in a more timely manner. First of all, we always recommend that you consider signing up on the web portal to submit disputes electronically. Like as Felicia mentioned earlier, electronic disputes tend to be resolved quicker, they're easier to track, and it also decreases the burden on you because you aren't having to deal with physical paper. Second, you also have the option of submitting claims together, otherwise known as bundling claims. To do this, we typically recommend that you create a spreadsheet that lists all of the claims along with a cover sheet and any supporting documentation and submit that to the plan. The benefit here is it makes it much easier to track. A bundle of claims is going to be a heck of a lot easier to follow than multiple single claims. Third, if you're dealing with a high dollar claim dispute, what you might want to consider is sending that dispute to the plan in multiple forms. This can include submitting the dispute electronically, as well as sending a dispute via paper copy through mail to both the address listed in the contract, as well as any address that's listed on your on the PDR form, which is typically posted on the plan's website. Just as a side note, while plans do offer PDR forms, you do not necessarily have to use that form, so don't feel obligated. And finally, if you are sending by mail, we always recommend that you make sure to maintain a log that tracks the submission because you want to make sure that you're aware of all upcoming and impending deadlines. Once you submit a claim to PDR, one of three things are typically going to happen. First, you might actually receive a written notice from the plan stating that they are overturning their denial and congratulations, you are going to be paid for the service or you can proceed with providing the service. Second, you might receive a written denial stating that they're going written notice stating that they are going to uphold the denial. Or third, you might receive nothing at all. If you receive, if you don't receive an approval or a denial within 45 working days, just as before, that's considered an automatic denial. And the PDR is considered exhausted at that point. What begins now is an assessment of what you want to do next. You can either abandon the dispute or you can elevate the dispute to litigation or potentially to some other type of advocacy. We highly recommend at this point that you consider consulting with legal counsel. They should be able to walk you through the strengths and weaknesses of any dispute that you might have with the plan. But in addition to consulting with legal counsel, there's certain things that you need to consider on your own. We refer to this basically as a value cost assessment. First, understand what are the value of the claims at issue here, and is it going to be worthwhile to bring a lawsuit? As Felicia mentioned earlier, sometimes bringing small individual claims on their own won't be worth it. But one option that you can do to increase the dollar amount is to bundle claims together. And this will increase the overall damages that you might be able to obtain through a lawsuit. If you are bundling, though, be cautious of any deadlines. You don't want to delay filing a lawsuit or going through a dispute mechanism in order to bundle more and more claims together, because eventually you are going to hit that window to file the dispute or the lawsuit is going to close. Another thing that you might want to consider as well is if the plan's behavior warranting some type of immediate relief. This is known as a temporary restraining order, a TRO, or a preliminary injunction. Unfortunately, though, I do have to warn you that in most cases, this won't be an option. One, because it must involve some type of a harm that can't be remedied through money damages. And also generally, your contract is going to contain an arbitration provision. So seeking a TRO or a preliminary injunction just might not be an option in that situation. Finally, you also need to consider just the expense and the burden of bringing a lawsuit. I like to compare lawsuits to home renovations. They're fun to watch on TV. They're a hassle to go through in real life. Sometimes they're worth it and totally necessary and justified. And at other times, they can be, a huge waste of time and money. But it's important to consider upfront, how much will this lawsuit cost me? How are you going to pay for it? In terms of what type of fee arrangement are you going to enter into with counsel if you're going to retain counsel? This could include an hourly agreement or a contingency agreement. If you do enter into a contingency agreement, just be prepared to give up potentially 30% to 50% of any award that you receive at the end of the lawsuit, potentially higher. You'll have to negotiate that with your attorney. And also consider if the contract you have with the plan includes an attorney fees clause. This can cut both ways. It's most often used as a leverage to encourage settlement between the parties. But if you proceed with a lawsuit and you are the prevailing party at the end of the lawsuit, you can get the entire cost of that lawsuit covered. But if the opposite happens and you lose on everything, you might have to pay the plan's attorney in that situation. And also remember, plans have more resources than you. They have very deep pockets and they are usually willing to dig through them. Finally, the last consideration is your relationship with the plan. If you have a good working relationship with the plan and maybe the claim isn't high dollar, you might want to consider not pursuing it. You don't necessarily want to ruffle feathers in that situation, and it might be best to let bygones be bygones. If you do decide to pursue a lawsuit, you're going to want to do a couple of things. And this is going to involve going to your contract and checking for certain provisions which might impose additional requirements on you. This can include a clause that requires you to actually meet and confer with decision makers from the plan prior to initiating a lawsuit. It might also require you to actually mediate the dispute through a non-binding dispute resolution process and hiring a neutral third party. And I'm willing to bet more likely than not, without putting eyes on any of your contracts, that it also includes an arbitration clause. And when you see an arbitration clause, that is essentially binding. You are going to have to put that dispute through arbitration, which is going to involve basically hiring a neutral third-party judge. Arbitration has the benefit of being fast. You could get a lawsuit resolved in potentially a year through arbitration, whereas a civil suit in public courts might linger for 2, 3, 4 years. The drawback of arbitration is it can be incredibly costly. You're paying the judge a daily rate for the hearing, often multiple thousands of dollars per day, and you also have to pay for his time to deal with any procedural issues or hearings prior to the actual trial hearing. So the money adds up quick. And the other issue is that it is non-appealable. So essentially you get one decision, one bite at the apple, and that's it. If for some reason you do have either a very narrow arbitration clause or no arbitration clause in your contract, you can also consider pursuing a civil lawsuit or judicial litigation. Yes, Felicia.
Yeah, so let me just say, for smaller organizations, I really like when there are meet and confer and mediation options. It gives you you a chance to really speak directly to individual leadership within the plan, and for them to understand and really pay attention to what's going on. It does not always resolve in a settlement, but when you're both contributing enough to go through mediation, it does take resources. I would say kind of the cheapest mediation I've done was probably 20,000 or something like that. If you include the arbitrator's fees and then the fees of the lawyer getting up to speed, that at that point, you have an opportunity. You've both committed that kind of money, and so it's a serious enough dispute that they're going to sit down and talk with you. If you can actually get decision makers in the room, you have an opportunity to hash through it. I
All right,
will
can
go ahead.
I just wanted to, you can keep going with your thought and then answer this in a second if it makes sense. But we did a good question that this section probably is appropriate for. Effectively, someone's asking about class action lawsuits, but
I
I
was
think
going
if
to
we
address
just,
that
yeah,
question.
broaden to the question of, with any of these dispute situations, if and when is it appropriate for multiple CBES centers to come together?
So that is going to depend in part on the language in your contract. Actually was, it historically was that you could enter into a class action lawsuit even if you had agreed to arbitration. But increasingly, what we see in arbitration clauses is that you give up your right or your option to join your issues with others that might be similarly situated. So increasingly what we're seeing is in contracts like managed care contracts that overwhelmingly elect for arbitration, there is a reduced option of is filing a class action suit. This is one of the places where, again, the plan is using their buyer power to their leverage for their interest. But again, that's what I presume. Every plan has slightly different contractual provisions. And so they might require everything to go to arbitration except claims under a certain amount of money, right? There are a lot of different variation. And so that's one of the reasons why we were doing this. We've only looked at a small handful of CBAS plan contracts. And so you would really just need to check those provisions to be able to ascertain whether or not a class action could be sustained.
And then as a related question here, something CADS has an official antitrust policy. Of course, we're bound by that and focus on that in all our interactions. Most of the folks on this call are members, they're familiar. They thought about it. When, if ever, do the antitrust concerns and claims disputes come into contact?
In an abundance of caution, when I advise provider associations, I always advise to never actually talk about numbers or any legal provisions like contractual provisions that could influence the numbers, right? So what you're looking for is you never want a meeting of minds on rates. So you don't want to be, it can get a little bit dicey when you have, let's say, I know there was a previous question that related to an individual center that may have had a higher reimbursement rate. If now they disclose that to everybody else at CAADS and everybody at CAADS went back to their plans and said, we want this amount as well, that would definitely trigger antitrust concerns. And so keeping that rate information confidential is really important. There is a narrow exception to that that applies when it deals with advocacy to public agencies that can sometimes be applied. So for example, the work that CADS has been doing advocacy to DHCS with respect to some of the rate issues and historically on the rate issues. None of that is subject to they're all fall within the North Pennington exception to the antitrust rules. But that's sort of my quick and dirty. There are obviously other things that can happen, but like you can all decide to strike or something like that. But let's not get into that level of detail.
And I'll just ask because I think it's implied in at least probably on some minds here. So there's the health net situation. A similar impact is being seen across centers. Everyone's generally familiar with it because it's sort of a boilerplate impact. Is it possible, advisable, if you're a provider and you know that other people had a similar situation, to try to pool your resources and consider litigation or dispute process, at a collective level rather than your center alone? Like if you're at your center and you're knowing this is probably impacting others, is that possible or advisable to think about coming together?
So this goes back to not touching rates, right? So I did mention there was a hospital group that was surveying its members to see what some of the biggest pain points were with respect to their local Medi-Cal managed care plans, right? What they were doing in terms of delayed payments, what they were doing with respect to unjustified denials, right? Whether or not they were moving patients timely. And they can talk about all of that stuff, right? And they can do advocacy with each of the plans on it. There was litigation last year by the California Hospital Association against Anthem Blue Cross regarding its failure to timely discharge patients. So there are things that don't come to the point of exerting market control that are permissible by a provider association or just a group of providers. Okay.
That's helpful because I think there's that's if you're seeing this and you have neighbors in the health net situation. So that's appreciated.
All right. You want to continue?
Yeah,
To
absolutely.
interrupt.
Um, So by this point, you're probably wondering, why do I have to deal with all of these steps? The plan is obviously wrong. Why can't I just proceed with suing them? The answer to that question is going to be something known as the doctrine of the exhaustion of administrative remedies, otherwise known for exhaustion. And you've heard me mention this term before. This is a crucial and vital concept. Keep this in the back of your mind whenever you're dealing with a dispute. And basically what it states is that before you can proceed to the next level of a dispute, a lawsuit, etc., you essentially need to exhaust or pursue other available remedies that were available to you prior. Exhaustion is, in legal parlance, what's known as a jurisdictional issue. And what that means is that it can be raised at any point in a lawsuit. A defendant might not address it at the start of a lawsuit, but they can bring it up much later. They can bring it up at trial. They can even bring it up on appeal. And if they win on the exhaustion issue, it could reverse everything. So you don't want to find yourself in a situation where you've dedicated money and time pursuing a lawsuit only to find out at the very end that your case is being dismissed simply because you forgot to fully pursue PDR or you forgot to fail to meet and confer. So that's it. So whenever you are in a dispute involving a contract, look to the terms of the contract to see what kind of requirements are imposed on you. So for example, some of the language which we mentioned earlier might be something along the lines of parties must meet in person within X days of the dispute to engage in a good faith attempt at resolution, or parties must mediate the dispute with a mutually agreeable mediator from the JAMS panel prior to filing any lawsuit. So just be aware of that type of language. In addition to making sure that you check off all of these procedural boxes, you also need to pay close attention to any impending deadlines. One of the most important ones whenever you are thinking about bringing a lawsuit or pursuing litigation is the statute of limitations. These are rules that essentially say you must bring a certain type of lawsuit, a certain type of claim within a given period of time. For claims involving a breach of a written contract, that period is going to be 4 years. And 4 years might seem a lot of time, but keep in mind that exhausting PDR and any other internal grievances or internal dispute mechanisms might be a long and drawn out process. It can involve multiple levels. And also, there might be a period of time where you're attempting to informally resolve the dispute with the plan, maybe just through email or phone conversations. These actions are not going to toll the statute of limitations. That clock is going to keep on ticking. If you are approaching the deadline and you are becoming concerned about it, one option is you could always reach out to the plan and ask them for what's known as a tolling agreement. Make sure it's in writing, and this will freeze the clock and allow you to kind of pursue those informal means of resolving the dispute. One other thing to pay close attention to is that many contracts can include shortened time periods for the statute of limitations. So a contract with a plan can say, any dispute must be raised within 2 years or 3 years. So it's not necessarily always going to be 4 years for a breach of a written contract claim. Look to the contract. And finally, a major red flag that you want to look out for when you're dealing with public plans is that the contract incorporates what's known as the Government Claims Act. This will apply a significantly shorter time frame on your ability to file a lawsuit. Now, it's questionable whether or not the Government Claims Act on its own actually applies to public entities, including MCOs. That discussion is probably best reserved for another day or another time. But generally, what the Government Claims Act does is it defines the causes of action for which you can sue state and local government entities, and also outlines the procedures that you must follow prior to following a suit against those entities. It was originally called the Government Tort Claims Act because it was limited to torts, but now it also applies to contract claims. This does not apply to equitable relief. Basically, that's just a legal terms when you seek a court order, having the court declare something or compelling another party to do something known as declaratory relief or injunctive relief. You don't have to exhaust the Government Claims Act. But if you are seeking money damages, and it is incorporated into your contract because you are contracting with a public entity or quasi-public entity, you will need to exhaust it. For a contract dispute, you must file a government claim within 1 year after the accrual of the cause of action. Typically, that's going to be the denial of payment. And the claim must be physically mailed or physically delivered to specific individuals. These are going to be the clerk, secretary, auditor, or governing body of the entity at the entity's principal place of office. All of these rules are set forth in more detail in the government code. The claim itself must also include specific information, basically things like your name, basically a short description of the circumstances giving rise to the problem, general description of the damages you suffered, and also an estimate. Basically, this is enough information for the public entity to look at the claim and decide prior to a lawsuit being filed whether or not they want to settle. One other place you can look for information about the Government Claims Act is on a planned website. I know LA Care has information on their website that details how you can satisfy the Government Claims Act process with them. Once you file a claim with the public entity, they have 6 months to approve or deny the claim. If a public entity does not approve or deny the claim within that time frame, it is considered denied by default. The only difference that makes is the time limit with which you have to file a lawsuit upon receiving a denial. So if you receive a written denial, you have to file the lawsuit within 6 months. But if the entity fails to issue any denial, you have 1 year to file the lawsuit. And that 1 year would begin at the lapse of those, when that 6-month period ends.
So thanks, Avi. So to recap on some of that, we don't expect we're hoping that you understand, you come away with this on some of the timing, on the authorizations, the claim submission, claim payment stuff. That's really important because that's going to be stuff you deal with day in, day out. On some of what we just talked about in terms of the strategy, the timing to file litigation, whether or not, you have to comply with the Government Claims Act. That's stuff that we're not expecting you to, or any client really of ours, to remember. We deal with that day in, day out. But the point of that is to remember timing is really important. So as soon as you start identifying something, you may want to keep track of just general timeframes. I mean, usually the shortest time is about 1 year. It's really confusing because I've seen public plans have a 1 year statute of limitation, but they also then require you to comply with the Government Claims Act before you can go into arbitration in 1 year. Well, that doesn't make sense, right? They have up to 6 months to make a decision on your government claim. And so that means that essentially you're cut down to 6 months to submit to a government claim. So that ends up getting condensed a lot. And at that point, you may not even realize there's a significant problem. So making sure that you keep track of all of these timeframes is really important because it's gotten a lot more complicated. And I think plans have been a lot more aggressive in trying to limit the ability of providers to escalate disputes. So now we're going to get to a slightly more interactive, and maybe we're an hour in, we're getting to what some of you were actually interested in. So typical managed care disputes, when you're first trying to get involved with a plan, licensing and credentialing issues. Then we also have utilization review issues with respect to authorizations primarily. Then we have payment and reimbursement disputes, including non-payment, reduced payment, and then overpayments asserted by the plan. And then the last one being contract termination. We're just going to go through some examples that we got from CAADS as to what might be relevant. We try to strike out the names of some of these plans, but we did not do that very effectively. So you'll have to give us a little patience on that. But this is a situation where the provider sent a request for CVAS services 5 times a week. The plan denies it and approves 80 units, which is about 3 times a week for that 6-month period. One of the things that you see here is they've given you basically no justification of why they've done that. So our initial thoughts on this particular issue on the next slide. So the plan has to provide a clear and concise written explanation of the reasons for denying, deferring, or modifying a service, right? They also have to tell you what criteria or guidelines they use, because those criteria and guidelines should, in theory, be publicly accessible or accessible through the provider portal. And so when they're making that decision, they have to be able to justify the clinical reasons for the decision based on medical necessity. Written communication to the provider must also include the name and telephone number of the healthcare professional responsible for the denial, delay, or modification of the service. So right away, what we see here is this modification should be invalid, right? They've done none of the work that they are required to do. And while you've got strong procedural grounds on that, I'm always a little bit zealous to make sure I don't give them a room to just fix the problem. And so at that point, I would, calendar the date for a potential appeal, consider whether you're going to use a provider dispute resolution or the enrollee appeal process, and then figure out, okay, what are, number one, pointing out the procedural processes that they're not providing you with adequate notice, but then also making sure that you again set forth why it is that the service is medically necessary. Okay, moving to the next one. This is a situation where it appears that there was previously an approval, and then they're now changing that approval to 4 times a week. So they went from 5 times a week to 4 times a week. But there is, some rationale. There's, some information that it was reviewed by a physician. There's information about the physician. Oh, and I'm sorry. I think, Avi, this one was you were going to cover.
Yeah, that's okay, but you did such a good job. Other things that you could point out as well is that if you, like Felicia mentioned, this was a reauthorization request. It doesn't actually provide documentation, but I believe at some point in the letter it says that a letter, or in this notice it says a letter will be forthcoming. And it also provides a appeal window where it says within 30 days that the additional documentation to support medical justification needs to be submitted to either via fax, it appears. So our thoughts in terms of this denial, it's important to keep in mind the difference between what constitutes a retroactive rescission and a prospective rescission of authorization, or in a sense, kind of a denial. Retroactive rescission of authorizations are prohibited by the Knox-Keene Act, as we discussed earlier. Once services have actually been rendered based on good faith reliance on authorization, the plan must pay you for those services. It cannot rescind the authorization. However, here in the previous letter, what we had was a reauthorization. So, in that instance, because it seems to be seeking authorization for prospective services, most likely, doesn't violate that rule against retroactive rescission. One other thing that you should note is that this one actually does identify the medical director. And in the past, we have had some clients who have experienced success with peer-to-peer discussions with the medical directors or the deciding doctor that they have had actual calls with the medical director or deciding doctor, and have actually had some success pursuing that avenue. It could help to sometimes establish, a face-to-face or voice-to-voice relationship with the individual to explain and walk things over the phone. What we've heard from some CBAS providers is that these medical directors really just don't understand the nature of the services provided, that they regard something like stabilization as a sign of improvement, and without realizing that a decrease in the level of service can actually result, in the client not doing as well, or the patient not doing as well. But if you are going to have a phone conversation with anybody at the plan, please make sure to document it extremely well. Keep detailed notes and make sure that that is something that you put in a patient file or record. Yes, Felicia.
Yeah, no, so one thing I was gonna raise on this also is that sometimes you have, so the physician that orders the CVAS services, maybe somebody who actually works for a delegated entity that's subcapitated from the health plan. So we have also had success where you have the patient, the client's primary care physician have a peer-to-peer with medical directors from health plans, because they're sort of on the same side, if you think about it. They're separate and apart from your CVAS center, but that can sometimes be effective. So because physicians like talking to other physicians to get a little bit mutual understanding of the patient's actual need.
Also, as with any other dispute, calendar to dates. And finally, one thing to also consider with these types of denials is maybe getting the client and or his or her family involved. Client appeals can sometimes be more persuasive and allow you to get authorization, especially if the patient's family is engaged in the process. Back to you, Felicia.
Yeah, thank you. All right, so this is one where, and my understanding, we didn't mean to pick on Molina or any other plan, but it's basically one where the claim is being denied because it automatically gets denied for Medicare being primary. So we move to the next slide, and I'm sorry, the text is relatively small. But the first thing, again, calendar the date of denial for purposes of appeals. But what we see is is in California, you have a lot of many plans growing. So it used to just be CalMed Connect. What was that, like 2014 or something like that? And then you have DSNP. I think all of the public plans have to now have a DSNP product. A lot of plans have a uniform way of programming claim logic, right? So they are not great at dealing with different kinds of providers. They want to have one kind of logic in their system and they don't want to deviate from it. Where it becomes problematic is that in a situation like this, they're going to always assume, oh, well, if there's a Medicare benefit, then we'll process it through Medicare first. And then if there's a cost share, then we'll consider whether or not there's any additional Medi-Cal benefit. But they don't really think about the situation where you have a product like a service like CVAS, where there is no Medicare benefit and it's only payable under Medi-Cal. And that's why you're getting these kinds of denials. This, if you ever see it, if you go back and look at the slides later, I thought this was a really good example of a succinct appeal of a claim denial by pointing that CVAS is a Medi-Cal only benefit. We are going to talk about, this is the kind of thing actually, going back to Brian's question. If this was something that was happening more universally and we were able to get good examples of it, this is the kind of thing where the organization could do could potentially do a group sort of advocacy. Depending on the contracts, we would have to assess who the potential target might be for that and whether or not it's something that's litigation or if it's something like political. But this is an area where it's not about the amount of the claim. It's about the systems not being established to accommodate CVAS. So the next example is one where there was a service that was denied. And I think this is the one where the patient is on hospice. So real quickly on the next slide, we've seen documentation that talks about Medicare. Medicare acknowledges that CVAS is sort of a unique kind of service. For hospice, Medi-Cal coverage mirrors the coverage in Medicare, which is governed by APL 25008. So there was an old all plan letter, and then now this is the new one. I will tell you, having dealt with plans on hospice, they don't really have a good grasp of how to handle the hospice. Like there's still a lot of plans that still really struggle with any kind of long-term care benefits at all. And then once you try to put together the interaction of something that there is not their bread and butter, like CBAS, with something that they already find confusing, like hospice, I am not surprised that there is confusion around this. But one of the easiest things that you can say that's supported by 25008 is that there are still services that are payable even though the patient has opted for CBAS, for hospice, sorry, notably any services that are not related to the terminal diagnosis.
And here we have our last example of a claim denial. Basically, this is just more shenanigans by the plan. You can see that the claim is being denied due to a lack of pre-certification, even though the services were authorized. And we like this because it kind of represents a nice, short, succinct model response, basically saying, here's the authorization number. Also, we've attached the authorization. Here's, the paid claim, et cetera, et cetera. All the details are present. And also, bonus points for the nice sentence at the end that say, payment for services rendered would be appreciated. So again, we think this is an example of a really good, succinct response. Yeah.
All right, we'll keep going because we've only got 13 minutes. Now we've gotten to the point of what one of the things folks are really interested in, which is being able to keep payments once you've received it. So the Knox-Keene Act, and I'm going to go through this real fast because I'm realizing we're running out of time. But Knox-Keene Act prohibits takebacks after 365 days of payment unless there is evidence of provider fraud or misrepresentation. The plan must notify the provider, and there are certain requirements in the written notice to the provider. We're starting to see even more focus on overpayments by plan. They have these special investigative units, and there's compliance enforcement. This is something that has really increased, I would say, in the last 10 years or so in Medi-Cal managed care. So moving to the next slide, the recent Medi-Cal exhibits that have gone out, I think for 2020, might have been retroactive to January 1, 2024. But it requires all providers to report and return overpayments to the plan within 60 days of identification. There is a legal conundrum of whether or not this is actually the same as the statutory 60-day rule, or if it is just a contractual requirement. If you're in a situation where a plan notifies you of an overpayment and you realize it's a bigger problem, but that problem might be, it could be very significant to your organization, it's probably worth having counsel take a look at the situation and assess what the potential risk would be because you're going to have this provision in all of your contracts. The new Medi-Cal exhibits also include a requirement that providers must notify plans within 10 working days of any suspected fraud, waste, or abuse. I personally hate this provision with a significant amount of vitriol. It is something that I'm pretty sure started, I think I saw it first in Cal Optima contracts. And at some point, DHCS was like, that seems like a good idea. Let's just make everybody do it. The problem is it is a ridiculous standard. I mean, it doesn't even give you a definition of what suspected fraud, waste, or abuse is. It could be basically almost anything, and 10 working days is just not enough time to run down a serious and potentially complex issue. And so I don't really love that one either. But it kind of in summary, the point of this slide is that notification by the plan that you might have an overpayment puts you on notice that you might have other obligations under your contracts with the plans. So back to receiving a notice of overpayment, you have a 30-day deadline to challenge the overpayment. If it's not challenged, if it's an undisputed overpayment, the plan has the authority to recoup against the current receivables. So what they owe you for current services, so long as they've provided it for it in your contract, and I almost guarantee you that they have. If it is challenged, then it gets treated as a provider dispute resolution. And I would contend that the plan's not allowed to collect that amount until that whole process is done, whether it just be through internal provider dispute resolution or if it goes up to any escalation beyond that. So with the next problem, and it's something that's going to sound very familiar, if you have a health plan that sends a notice to a provider stating that it has determined that it paid at the wrong Medi-Cal fee-for-service rate due to a mistake with the DHCS website, which it alleges has been retroactively corrected. The health plan demands repayment or threatens to withhold payment for future claims. So the first question is, was there actually an overpayment? Well, actually, no. The first question is it more than 365 days? Because then you've got an argument that if they have an alleged fraud or misrepresentation, they're time barred. And does it include the information that is required by the regulation? And then once you get through that procedural stuff, then you get to the question of, well, is there actually an overpayment? In this particular circumstance, you have the issue with, next slide, that your contract is likely to define your rates in a lot of different ways. And I came up with some language that actually looks the same and a lot of people might think is the same, but can have slightly different interpretations in different situations. And so getting a better sense of what your contract actually means, and whether or not there is an overpayment. If your contract identifies a specific rate, then it's possible that, this issue with the fee schedule may not apply to you at all. Then I will note that if it's talking about the Medi-Cal rates, for example, or the published Medi-Cal rates, that kind of goes back to the what is the truth of what the fee schedule is. The Medi-Cal state plan, which is sort of the document that governs the Medi-Cal program, points to the fee schedule website as the source of truth. And the Cal waiver in turn references the state plan. So there is some legal argument that really should be the rate, and there's not really an the state doesn't necessarily have authority to retroactively correct rates. But that is a legal argument. It's not necessarily ultimate truth. And so that's something that you're going to want to assess as you determine whether or not there is truly an overpayment. Okay, last issue is, so practical steps. Make sure you're calendaring. And if you do think there is an issue, you're going to want to make sure you start a good faith investigation of the alleged overpayments. All right, the last issue is terminations. You can cover this quickly. Maybe we'll have a minute or two for questions.
Sure, just very quickly, termination will come in two forms. The first is with cause. This will be triggered by what's known as a material breach of the contract. In other words, you violated a specific term, very important to the contract. In this instance, usually the notice, which will be sent to you, will also include a cure period, or the contract itself should include a cure period, which means you can fix whatever conduct it is that is causing the plan to want to terminate the contract with you. With cause is going to be generally the termination will take place in a shorter period of time, and it can also potentially include penalties such as like a blackout period for which you can no longer contract with that plan. Without cause is just a termination with no reason needed. They just don't want to do business with you anymore. That's it. End of the relationship. Generally, you'll get a longer notice period in this instance, maybe 3 months, 6 months, etc. It's all going to depend on the terms of your contract. One thing you should check for is whether or not your contract includes the right to appeal any type of termination that you receive from the plan. If you receive a termination, just remember that does not necessarily mean you are barred from continuing to treat your patients. The continuity of care doctrine is found in both the Knox-Keene Act as well as it's also imposed by DHCS. With Knox-Keene, continuity of care is required after termination provider agreement for specific problems or conditions. This includes a serious chronic condition for up to 12 months, but it must be requested by the enrollee. DHCS requires continuity of care for seniors and persons with disabilities who request continuity of care for up to 12 months. So you can always inform your patients, even if the contract has been terminated, that they can continue to see you under continuity of care. Just be aware that if you do continue, that if continuity of care does apply, you might continue to be bound by the terms of your contract. and you'll be paid at rates that are generally established by the contract.
All right, so, oh, sorry, I
Oh.
forgot about the last few sites. So there are always some alternatives, and I posit these not necessarily as the first option, but it is something to be considered. There is the ability to submit provider complaints to DMHC for unfair payment patterns, which is a term that's defined by the Knox-Keene Act. After you've exhausted the plan's internal dispute resolution process, you can submit documentation to DMHC with the PHI redacted and showing what the issue is. And DMHC might make a determination that the plan has failed to comply with the Knox-Keene Act, and determine whether or not the claims should have been paid. So there is that process. There is also the ability to report to DHCS. It is also a little bit aggressive because the plans see DHCS as their regulator. And honestly, DHCS, I find them to frequently just say, well, we don't get between plans and providers, which is a little bit less than ideal, given that they are supposed to be the watchdog here. And then here's something where CAADS is and has historically been very active, is there are other kinds of advocacy, whether it be educating legislators so they understand the program, or advocating for specific legislative action, or regulatory advocacy to the agency, as they did here, to make sure that CBAS continues to be a benefit and continues to be payable by the plans. All of that are places where there can be advocacy. And so those are alternative strategies. I put creative strategies here in part because to the extent this presentation is made public, I don't think anybody wants a record of them advising riders to NERC, to DMHC or DHCS. So with that, we're hitting up right up against 4 o'clock. And we appreciate all of you staying with us until this time. Again, I appreciate CAADS for giving us this opportunity. If there are any questions, feel free to raise your hand. Otherwise, we have our information. I think maybe we don't have our information in the slides. Usually I put it in the questions page, but feel free to email us if you have any questions.
Yeah, and so thank you guys so much. We did have a couple questions throughout the webinar. I answered a couple individually rather than bringing them up. So appreciate those questions. A couple related to HealthNet, and if you do have an idiosyncratic situation, you can feel free to email me, brian@caads.org, and we can connect on individual issues. I can also put you in contact with these guys, Felicia and Avi, who are our great partners here and continue to guide us at CAADS. But seeing no questions here, I'm just going to end by saying, again, everybody, thank you for getting a better context for how managed care has to approach various things, and then what your options are. Felicia and Avi flagged very critical best practices, including tracking timelines for all interactions with managed care. So timelines. You guys are very familiar with that, but in a dispute situation, it's even higher stakes. So a couple of those I'm going to mention again next week when we talk about HealthNet in particular. But I want to thank Avi and Felicia for all their information, and especially sharing some of those best practices in terms of just what should you be doing in even if it's not escalated, but to prepare yourself, and then as you go through a potential escalation, how it might look and feel. So with that, we'll thank everyone for attending. We are going to do a recording of this, make it available to CAADS members. We did cover so much ground that I imagine lots of folks will want to revisit certain sections of this webinar. So reach out to Nikki. Her email is Nicole, Nicole, Nicole at CAADS. Nicole at CAADS. She can connect you with the recording in the future. With that, we're gonna say thank you to Felicia and Avi, and we will see you guys and other CADS members on Thursday next week, the July 31st at 2:30 p.m. to talk about HealthNet. We will go over some of this and we'll help you navigate your options for the HealthNet situation. So thank you guys so much, and we'll you guys will see Felicia and Avi in the future because we continue to rely on them.
Thank
All
you,
right.
Brian.
Thank you.
All right. Cheers, everybody.